Hi, everyone. This is Camille Sams with Caliber Home Loans, your Zen lender. And joining me again today is Erica Carter Walden. And we are going to be picking up part two of a two-part series about the probate process. And as I've introduced before, Erica is with Pacific Playa Realty, and she's also a probate attorney. So she understands very intimately the how, why, what, when, where of the probate process. So as mentioned, this is part two. So I'm going to let Erica pick up where we left off last time and just kind of do a brief little recap just to kind of bring everybody up to speed.
Okay. Well, hi, everybody. So last time we talked, or in our last video, we covered the beginning of the probate process. Someone passes away, they have $166,250 in assets with either a will only or no estate plan. And so then we need to do something with those assets. So we filed a probate petition. And we went all the way through that process up until the point where the personal representative is now appointed. The court says, yay, the order is granted, you can start administering the estate. And so at that point, you can now hire a realtor. And I'll tell you what happens from the court's order on. So in today's video, we'll cover again what happens when we agree to work together, or you hire a realtor to work with them, and then
Who else would they
there's
go
so
to
many.
work with?
Say again?
Who else would they go to work with? Of
I
course they're
don't
going
know.
to hire you.
And who else would they hire to do their loan once they sell the property and then get money and want to buy another
Right,
property?
right,
Why would they go
absolutely,
anywhere else?
absolutely.
So when we agree to work together, but while I'm doing my work as the realtor, there's a lot of other stuff that you should be doing while we're marketing the property and then selling it. So that's kind of what we're going to talk about.
Okay.
So congratulations, you've made it through all that we talked about last time. You now have your order. It takes a while for the letters to come, 6 to 8 weeks before COVID. So we'll have to talk to a practicing attorney about what the process is right now in LA County. That's typically what happens. As we talked about last time, other counties are a little bit different. Riverside still has a lot of people. And so San Bernardino, it's a little bit faster, but LA, there are a lot of probates that go
Right.
through LA County.
Mm-hmm.
So one of the first things you'll do, you'll take your documents and then you'll go open an estate bank account.
Mm-hmm.
You'll need a tax ID number because eventually you'll be paying taxes for these on behalf of the estate, but you'll need to make sure your bond is in place, all those things, so your letters can get issued. Bonds are, the premium is paid annually, so you'll pay once and then hopefully we'll have the property sold and you'll close the probate and then you want to pay a second time. But it's on average, from the time you file the probate petition, it's about a year. So it can be plus or minus that year to close the probate. People do not understand that. It's from the filing. And if there's fighting before appointment, that delays the process. If you don't have your documents and your ducks in a row, that prolongs the process. So plan out for about a year in order from start to finish. And then it can go shorter or it can go a little bit longer. So again, you'll have to get your tax ID number. You'll begin your inventory. So you'll go through all of the house and say, okay, well, there's 3 cars, there's an RV, there's a painting that may be worth whatever. And so if it's a really nice painting, you'll have to get it appraised.
Right.
But if it's just household items, most people just have regular household items.
Mm-hmm.
There may be some jewelry of worth. You'll have, that valued, but you'll go through and you'll inventory all of those things. And then if you have limited authority, again, we'll talk about the video for limited authority, talk about specifically limited and full authority on a specific video because it's a lot. But if you have limited authority, you'll have to wait for the probate referee to issue their appraisal of the property. And from that appraisal is where you would set the list price. If you have full authority, we would just work together to see what the condition of the property is, what the comparable properties are, and then market the property according to what the market value, what we think the market will price the property will go for on today's market.
Right.
But if you have limited authority, our hands are kind of tied because we have to list the property within 90% of that appraised value. And
Mm.
again, we'll talk about it more specifically on that video, but
Mhm.
at this point we're going over the listing agreement, and we're talking about price and terms and different things like that. So I know that you guys may be anxious to sign the listing agreement, like, oh, I'm ready to sell this property,
Yeah.
but it is really, 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 really important to wait until after you have been appointed. And we talked about that a little bit in the last video. Again, on the realtor side, you may be negotiating or contracting with someone that may not get appointed. So now your contract doesn't mean anything. Somebody else may have priority, or they may have requested full authority and the court's like, no, I think
Yeah.
we should supervise this a little bit more. And so
Mhm.
then they get limited authority, and now you have to change your documents.
Mhm.
Again, you're as the executor or administrator, you are signing the documents in your representative capacity. You don't
Right.
have that representative capacity until the
Mhm.
court gives you the representative
Mhm.
capacity. So it's Camilla Sam's administrator of, John Doe's estate. Well, you're
Right.
not administrator of John Doe's estate until the court tells you are. So you can't really
Right.
sign the documents ahead of time.
Mhm. Mhm.
Um, and then some lawyers just don't like it. So then you're off on the wrong foot with the lawyer that you
Mhm.
have to work in partnership with because you signed documents and listed the property before they really felt comfortable for you to do that.
Yeah.
So you sign the documents. Some lawyers will say, go ahead and sign it now that we have the order, go go forth and market the property. I have had this happen several times when I'm out doing or out running a foreclosure.
Mm.
That's usually because of a reverse mortgage that
Mhm.
nobody knows where the documents are. And all of a sudden they're like,
Yeah.
we're in pre-foreclosure, we're in
Right.
foreclosure, because the company sold it to another company who sold it to another company, and nobody
That's
knows
what
where the
I was going to say, because a lot of times what happens is that these loans have been sold off. And so in our industry term, that's the servicing. And so that's the company where you're sending off your mortgage to. And so it's changed, particularly with reverse mortgages. It's happened so often where the servicing has been transferred and transferred and transferred that, and to your point, even if you have the original paperwork, trying to go down that rabbit hole looking for who now holds the servicing and who has the right to speak about this mortgage becomes really, really problemsome.
Yep. Yeah,
Hmm.
it can become problematic because they either can't find the paperwork, or they find the paperwork, like you said, and it's like 8 companies ago. And
Yeah.
then talking to the person before you get your appointment, some companies will talk to you. Some are like,
Hmm.
nope, we need to hear it from the court first. And then all that time is passing, and they're not very understanding about the fact that you're in probate. They just want their money. So not all companies are created equal. I've dealt with some reverse mortgage companies that are very understanding because they know that this happens quite a bit, and they allow you the time. They say, okay, well, give us some evidence that it's being marketed,
Right.
that we're
Right.
going to get
Right.
paid.
Right.
Others are cutthroat and they
Mm.
don't care.
Mm.
And so just like every person's not created equal, every company's not created equal. And then
Hmm.
sometimes people within the company aren't educated enough. Like the company may be okay, but that person doesn't know that they have the ability to extend
Hmm.
some
Hmm.
grace
Hmm.
and
Hmm.
allow you to, put the property on the market it, and then get it sold.
Right.
So I have had to race the clock a couple of times. And so
Hmm.
that's a conversation you have with the lawyer. Hey, there's a reverse mortgage. I understand you want to wait for the letters to come to get in hand in 6 to 8 weeks. We need to do something right now. We need to show
Right.
them our listing agreement, put up a
Yeah.
sign, take a
Yeah.
picture, send it to them. So they
Yeah.
will allow us that time to be able
Right.
to close.
Okay.
So it's really, 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 really important
Hmm.
that I say enough reallys that you hire a realtor that actually
Yeah.
understands probate.
Yeah.
I know that everybody knows a realtor. I
Right.
know that you may have a cousin who does real estate on the side. You may have a
Hmm.
neighbor. You may have
Hmm.
your sister's friend's cousin, Mary, who has sold other properties. Probate is very, very, very specific.
Yeah.
It's important that you hire someone that understands the probate process, because in addition to the listing agreement that has extra
Hmm.
stuff
Hmm.
that has to
Hmm.
be attached with it,
Hmm.
um, in LA County, there's a cap on commission.
Mm.
In other counties, there's not. In LA, there's a cap on the commission. The maximum time for your listing agreement in under the probate is shortened. Like you can't sign a 1-year listing agreement. You have
Wow.
to sign. It has to be stated in the listing agreement. There's specific boxes that must be checked on the listing agreement.
Okay.
When you market the property, you must indicate whether there's full or limited authority, because that triggers other things. When
Mhm.
you're put it on the MLS, if it's limited authority, you need to say that it requires court confirmation. There's generally a larger deposit that the court requires.
Mhm.
And when people put that deposit in, if you go under contract, and we'll talk about this in greater detail,
Right.
and you want to back out, you may not get to back out until the court says release that you can have those funds released. So on the buy side, it's important, but on the listing side, you also need to
Right.
be able to educate people who are coming to buy the probate property.
Right.
They have to put their purchase offer on a probate purchase agreement. There's specific things that have to be done.
Mhm.
And if it's a multifamily probate, which I've sold, there's other things that you have to do. So
Mhm.
you need to work with someone uh, who understands this. The attorney will be very, very grateful, and their paralegals are even more grateful when you call and say, "Hey, I've done a lot of these," or "Hey,"
Right.
I call and say, "Hey, I'm a lawyer.
Right.
I practice probate." They're like, "Oh, thank God, we don't have to do your job
Mhm.
at
Mhm.
our
Yeah.
job. We have enough
Right.
to do."
Right.
So, and then there's other things that just have to happen in limited or full authority. Before a probate closes, there's some sort of court action that has to take place.
Okay.
It's not court confirmation in full authority, but there's a notice that has to go out. And so you have to loop the lawyer in and say, okay, we have a buyer that we're considering, or we have a buyer under contract. It depends on what the lawyer wants you to do. So you'll have to
Mhm.
talk to them.
Mhm.
Some lawyers are like, send me the contract. Any contract that you're thinking of looking at, send it to me. Other lawyers are like, just tell me when you have somebody under contract. But you
Yeah.
have to be in communication with
Right.
that lawyer, and you have to know what to say. You have to know
Okay.
what terms you need to say, and you have to have your documents together.
Right.
Um, so it's really important that you work with someone who has done probate before,
Mhm.
and they can look at somebody else's listing agreement and check the boxes, but there's other things that you need to know how to do
Mhm.
in the process and
Mhm.
when to do them.
Okay.
So while I'm handling the real estate part of it,
Mhm.
because I know what I'm doing, and marketing the property day to day and handling the day to day operations of that and keeping you in the loop, because that's the other thing. You need to be in communication with your client. Okay, this
Right.
is what's happening. We're showing the property if it's occupied or if there's tenants. We have to give note, like all these things. So I'm handling all the day
Yeah.
to day stuff. While I'm doing that, you have other things that you have to manage. So some of those things include approving or disproving creditors' claims.
Mm.
Because just because you died doesn't mean people say, "Oh, it's all forgiven.
Yeah, no,
You don't
they
have to
don't.
pay anything. God bless
Right.
you.
Right.
May your family have peace." They don't care.
They'll come
Your
after
debts
your
don't go
family
away.
even if you don't have assets, even if you don't have significant assets.
Yep.
They'll come after you if you've divorced. They'll come after you. Yeah,
Yep.
I've had that. We've had that experience. Yeah.
Yep. So creditors claim period is a big part of this process of what administrators and executors, personal representatives will be handling.
Okay.
So there's a
That's good
statutory
to know.
period in which creditors like credit card companies, utility companies, all of them
Mm.
must file a claim to be paid. So
Okay.
as the personal representative, you must determine if the claims are valid
Mhm.
and should be paid.
Right.
And then B, you can negotiate those payments down if possible. Some law firms,
Okay.
the firm I used to work with, the paralegals help negotiate down the claims. Some people don't
Okay.
know that they can try this. But not all the time can it happen. But
Mhm.
if your property is if you're only gonna net $100,000, which is, I'm saying only, but if you're only gonna
Right.
net
Right.
$100,000 and the person has $150,000 in debt, you need to be able to tell the creditors, okay, well, we want to pay you,
But we don't have enough
but
to
we
pay
don't
you.
have enough money.
Right.
So
Right.
can you take a little bit of something
Yeah.
or risk getting nothing because
Right.
other people, we have to work something out
Right.
here.
Right.
So there's some probates where you're going to be working for nothing. You're going to be working to
Mhm.
pay the creditors. You're going to
Mhm.
be selling the house to pay off the taxes.
Mhm.
Sell the house to pay off Medicare or other encumbrances. you're not
Mhm.
going to get a dime. The beneficiaries,
Mhm.
heirs are not going to get a dime. There's going to be some probates where it's like that,
Mm.
unfortunately.
Mhm.
Um, so you're going to be working and get no money.
Mhm.
But then there are cases where you are able to, the claims don't outweigh the amount of money. You may not just get a little bit of money, but it's work. It's work to do
Mhm.
this. And so you
Mhm.
have to, you have to also determine, like, again, like I said, you're not just saying, okay, the claims or the money is owed. You actually have to look at these claims and say, okay, well, um, this Macy's bill happened after Aunt Betty was dead. So what happened here? We're not paying this. So you have to make sure that I mean, it could have been cousin Larry who's like, oh, Aunt Betty got a large credit limit. Let me go on and charge this card. You have to be diligent in kind of figuring out what are proper debts or proper claims, and
Yeah.
what is just not. What could be fraud or just, a mistake. So
Or
you
family
have to.
taking advantage of an
Yes.
ailing family member.
Yep.
And I mean, that's part of what I'm shaking my head. And, I've heard so many stories about that. And that's so, so sad. It's so sad. But, I'm sorry. It really is sad, like you're saying. Either the person has been in the hospital, or the person is incoherent. Maybe they are home, but they're not lucid. And then, like you said, all of a sudden you see, or I've had situations where people have contacted me, and grandma's got great credit, and we want to buy a house in grandma's name, and then I go to pull grandma's credit and find out grandma's credit cards are through the roof. And I'm going, grandma's on Social Security. Like, why, why are her credit cards through the roof? And you found out, Uncle Larry has been going to town, like ran up $5,000 at Sam's Club. So
Right.
anyway, it's really unfortunate that people do take advantage of family members
Yep.
on their dying bed. So anyway.
And as the personal representative, you are the fiduciary for the estate. So
Mm-hmm.
it is on your watch to make sure that all of that is
Right.
rectified. That Uncle Larry gets cut off,
Yeah.
and that the creditor knows, okay, Aunt Betty is deceased. This credit card is not supposed to be in use anymore, and these claims should not be attributed to her. Now, whether or not you want to out Uncle Larry, that's a whole nother situation. They have cameras in their own store, so you don't have
Yeah.
to say, well, Uncle Larry, cousin Larry, whoever he is, did it.
Mm-hmm.
What you can say is grandma was in the hospital
Right.
for 3 months before she passed
Right.
away.
Right.
We can get a doctor's note saying that she was incoherent, or whatever it is, and
Incapacitated.
she died
Yeah.
on this day. We can
Yeah.
give you a death
Yeah.
certificate. But you're trying to marshal and secure all of the assets for the estate. You're trying to disprove or reject claims that are not valid, and negotiate the claims that are,
Right.
and keep as much money for the heirs and beneficiaries after that as possible.
Mm-hmm.
So, and it's a job, and so that's part of your job.
Mm-hmm.
That's not the fun part of your job. None of this is really fun because you lost
Mm-hmm.
someone that you cared about.
Right.
But it's not it's work, is what I'm
Mm-hmm.
saying.
Mm-hmm.
So the creditors have 60 days after they've been provided notice of the person's death. So I called Macy's and said, okay, cut the credit card off, grandma's dead. You are on notice now.
Yeah.
Or they have 4 months after the issuance of the letters from the court. So remember when in the last video we talked about how we filed a notice or publication in the
Mm-hmm.
newspaper?
Mm-hmm.
We notified all the world,
Mm-hmm.
or all of LA County, this person is dead. And so the, Medicare, Medi-Cal, those places, are always going to kind of be in line, like, okay, well, this patient passed away, and you do need to tell them, you need to call on Social Security and not keep cash on Social Security checks, because we don't want you in jail.
Yeah.
But that's a sidebar. So you need to call the franchise tax board, Medi-Cal, all those
Mm-hmm.
things,
Mm-hmm.
within a certain time, and say, hey, come pick up the bed or the equipment. We no longer need this. Stop
Mm-hmm.
issuing checks.
Mm-hmm.
Those types of things, because for example, when my father passed away, he had gotten a check. He passed away toward the end of the month in May of 17. And we got the check for Social Security
Mhm.
either right after he passed away or right before. Like it was like
Mhm.
days.
Mhm.
But I knew that they were going, no, it was a few days after. So I knew that they were going to take that check back. So
Right.
I knew to leave the money in the bank
Mhm.
because they're going to snatch it back because he passed
Mhm.
away.
Mhm. Mhm.
So people don't know that. They're like, oh, okay, he passed away on the 27th. The check came on the 1st. I'm going to use that to pay funeral expenses. Well, you may, but then you're going to owe Social
I've
Security
had
for
VA widows that
yeah.
happen too.
Yep.
Yeah. Mhm.
So you have to be mindful of that. Like those little bitty things that people don't tell you until somebody's
Mhm.
passed away, and then now you're having
Mhm.
to deal with, I have to pay back Social Security, this money that I don't really
Mhm.
have, you know.
Mhm. Mhm.
Um, so again, personal representative has 30 days to allow or reject a claim once it's been made. So, um, you know, a creditor says, okay, you owe $40,000. You have 30 days to say, okay, we will pay the 30. This is valid. We'll pay the $30,000, or we can't pay you 30. Will you take 20?
Mhm.
Um, or just say, 15 of this is not valid. The other 15 is valid. We'll pay that 15. So you have to do something in writing. There's a form. You have to do
Right.
something in writing that has to be filed, that says you're accepting the claim or rejecting it.
Now I have a question. So when you say that you would be accepting it, regardless of if you're negotiating or not, let's say you decide it's a $40,000 claim, you say you're going to pay the 40,000. Are you agreeing to pay that within a 30 days, or you're agreeing that once the estate is settled, we will pay you this amount of money?
Well, once the estate is settled, because you don't have any money. I mean, you,
Right.
you do
Right.
have, you presumably, if somebody left you some money in an account, yes, but
Right.
presumably you're waiting for money to come in from different
Right.
places. You're marshaling assets. So you're saying, okay, we know we owe you this. We will make a payment arrangements for this once the probate
Right.
um, is done.
Right.
Now, some people may pay, and this has happened, to stop things from being taken away. Someone may give money to the estate, like one of the beneficiaries may say, I'll pay that, but I want it back from my beneficiary share. That happens in rare circumstances. I don't like people loaning money to the estate and money go, because it can
You lose
create all
track
kind of
of it.
problems.
Right.
But if there's an urgent situation,
Mm-hmm.
but I wouldn't do that. Just
Mm-hmm.
oh, here, I'll get it back. No, just, you're
Mm-hmm.
talking to the creditors. You're saying, okay, once the estate has the money and we're allowed to make the payments, because we don't
Mm-hmm.
have any money right now, we will pay
Right.
you. We understand that this claim is valid.
Right.
Please hold on. Your money is coming, because
Now,
generally people don't have money to pay originally,
right.
right off the bat.
So I became aware, I wasn't involved in this transaction, but one of the other agents that I work with who does probate, he's familiar with the process. He had one where he had to step in and it was a foreclosure situation. So they were getting ready to lose the property, and he brought a buyer in to pay the $30,000 that would stop the foreclosure. Um, let's say you don't have a buyer. Let's say it is something where the home is going, you don't necessarily have a sale date, but maybe it's heading that way. And you're another like 30 or 60 days away, and the person passes away. And this is a real situation that I think that we should be talking about, because we do know that there are some grave circumstances for people coming up with coronavirus that have complicated people's health and may have put them in a situation where they haven't been able to keep up with their payments. So let's say that the person passes away, there's a past due, and the home is getting ready to go into foreclosure. If you file showing that the person is now deceased, so this is kind of like a two-part question. If you file showing that the person is deceased and now you're going into a probate situation, they had a will, let's say, and there's been an executor named, does that put the situation on hold? So that's one part. The second part is, can one of the beneficiaries of the estate come in and say, look, I'll pay the $30,000 to halt the foreclosure proceedings that are getting ready to, or whatever, like past due or something, is, you know, so again, two-part question. Are those options? Is that something that takes place?
So for part number one, it doesn't
Mm-hmm.
automatically, filing a probate doesn't automatically stop a foreclosure proceeding. The
Mm,
lawyer needs to go in. If you can't negotiate that and say, I need you to stop the foreclosure because this and this and this is happening. If they're like, we're forging forward, we're rolling down the hill,
mm,
like is what has happened a couple of times. I said in a couple of the reverse mortgage situations, if that ball is rolling down the hill and they don't care, then the lawyer needs to go get in and get a stay. Like they need
okay.
to be able to halt and say, look,
Mm-hmm.
we're going to pay you,
Right,
but we won't have anything to pay you until this is done. And we are
right,
actively working toward getting you your money.
right.
So some companies are just, you know, they don't have
The empathy.
the
Mm-hmm.
empathy
Mm-hmm.
to,
Mm-hmm.
you know, to halt the process.
Mm-hmm.
And but I've worked with a lot of companies that do. They're like, okay, well, we understand somebody passed away. Please just show us. We need X, Y, and Z
Right.
from you that shows that you are actively trying. Like you're not just sitting there, okay, well, we just go chill in grandma's house until the probate's done in about a year. We're not going, you know, they want to know that you're
Right.
doing something.
Right.
And so once you show evidence that you're doing something, then they're okay.
Yeah.
But there are other companies that are like, yeah, no, we're going forward. And then the lawyer has to step in and say, no, you're not.
Yeah.
You
Yeah.
need to wait.
Right.
And we're giving you an order to wait.
Okay.
So that's part one. Part two is the circumstance that I was talking about before, where somebody can come in. It's an extenuating circumstance.
Right.
Like I said, I don't want, as a lawyer, I wouldn't want people just money just being loaned and I'm gonna get it back because it
Right.
may not come back. Like the property, somebody may have forgotten to pay the insurance. There may be a fire, and the house, the asset may go up in smoke, and then there's no money.
Yeah. Yeah.
So,
Yeah.
you know,
Yeah.
I actually went into my pocket on one transaction. I did get my money back at the end of the transaction, but because there was nobody else to do it, I
Yeah.
paid for landscaping because there was a two huge trees in the front of the property. Nobody was coming. They didn't pay the landscaper. Nobody was going to cut the
Mm.
trees down. The grass was brown as I am, and I'm brown. And there was no insurance on the property. We're
Right.
selling the property. If a spark had lit, the house
Yeah.
could have gone up in flames.
Yeah.
I'm like, okay, well, no.
Right.
I talked to the lawyer. We're going
Right.
to get our money back for landscaping, but these trees, this is a fire hazard.
Yeah. Yeah.
The
Yeah.
property is going to
Right.
burn.
Okay.
So there are those situations where you
Right.
can do that, but those are extenuating circumstances. Again, I don't, that's not like the first thing that I would go to. I try to solve
Yeah.
the problem a different way.
Understood. Okay.
So that's the creditor's claim period. The other things that you'll be working on is you will need to file the last tax return for the person that passed away. So
Mm.
they have to, the IRS is going to get their money coming or going. So is the franchise tax board. So
I love how you put that, coming or going. They're
coming
gonna
or
get it.
going. I'm just saying, there's nothing.
Right.
What's the saying? There's nothing guaranteed but death and taxes. And so
Yeah.
now we're talking about both. Somebody
Yeah.
died, you got to pay their taxes. You got to file
Wow.
the last tax return for
Right.
that person.
Right.
And then you may need to file a tax return for the estate. So if the estate made no
Mm.
money, then you don't have to. But if the estate makes some money, i.e. from the sale of real estate, you'll need to file an estate tax return. So you'll
Got
need
it.
to take care of that.
Mhm.
So all of that's going on separated and
Right.
apart from the sale of real estate. So I'm
Right.
not involved in any of that, but
Mhm.
you need to be
Mhm.
involved in all of that. You need to be
Mhm.
getting updates from me as the realtor. This is how it's going, but you also need to be approving and disproving creditors' claims. If you are working with an attorney, they're handling that,
Well, that's what I
primarily.
was going to come back and say. I mean, it goes back to what we were talking about at the first video, that this is why it's important that you have an attorney that understands probate, because you've got the attorney that really is in the middle that's handling all of it. So,
Mhm.
like the executor and the attorney are the ones that are really working side by side, handling both the real estate transaction, liquidating the assets, and handling creditors. And, so there are a lot of moving parts that are going on. It isn't just, okay, like you said, grandma died, let's list the property, and 3 months later we're going to sell this house, and then we're going to go, skipping down a yellow brick road and with our fortunes. There's so much that's going on. So I just wanted to interject that you've really proven the point of the importance of bringing on an experienced attorney.
Yep. Yep. Your team needs to be really together. Like,
Mhm.
they really need
Mhm.
to understand probate. What I will say is that some lawyers don't work with the creditor's claims. Like, they'll file the paperwork for you, but they're not going to negotiate on your behalf
Mhm.
or negotiate for you. Our law firm did, but I know
Mhm.
some law firms that are like, look, we're solo. We don't have the capacity for this.
Right.
So you're going to have to handle, they'll file the, the rejection or the acceptance claim with the court for you, but they need you to do the legwork. So that's
Right.
another discussion you need to have with the lawyer. Like, okay, how involved or how much hand holding do you do? Are you more hands off? If I need you to be hands on, will you be? That type of thing. So those are
Right.
questions that, as you're interviewing realtors to see if they know what they're doing,
Right.
you need to interview lawyers to see do they know probate, and then B, how hands on are they with probate? Most
Mhm.
likely you'll be interacting with the paralegal.
Mhm.
And paralegals know everything. I'm just going to tell you that. They're like the lifeblood of a
Right.
law
Right.
firm.
Right.
I would have been lost without my paralegal. So you'll be interacting with the paralegal. So you just need to know how involved you're going to need to be. So that's part of your interview process with the lawyer.
Understood. Okay.
So wrapping it all up
Yeah.
with the probate. So after you file the creditor's claim, after the creditor's claim period has passed, and
Mhm.
then all debts have been, kind of accounted for, paid, if you need to pay, if you have money to pay those, or if you've made arrangements. Tax returns have been filed. The personal representative will then file a petition for accounting or final distribution.
Okay.
So the accounting basically just outlines what came in, what was there. It's like a a statement of what we're accounting for the money is basically what it is.
Right.
This is how much money was there at the beginning of the opening of the probate. This is how much we spent. This is how much we gained, like, that came in. And then we're accounting for every single nickel dime of what we did. Like, we
Got
paid
it.
for landscaping, we paid for this, we paid for this, we paid for that, we had to do this, we had to do that. Beneficiaries can waive, or heirs can waive a final account. It's a lot of work for someone to do. If they don't have to do it, if everybody's in agreement that, Jane is handling all of this, and we trust that it was just one house, she negotiated the creditors claim, we don't need her to do all of it. They can waive it
Right.
in writing. But if somebody wants to just be kind of a pain, they don't have to sign the waiver, and then you have to do the accounting.
Mhm.
The final distribution petition, just like you filed the petition for to open the probate, you need to file a petition to close the probate.
Okay.
So it tells you how much assets, or what the assets are, list the assets that are in the
Mhm.
probate
Mhm.
and their value. And it talks about how much the attorney and the personal representative are to be paid. Their payments are statutory. So if you go to the probate code, which we won't go that far in detail, it gives you a breakdown of what everybody is allowed to get based on
Okay.
the value of the estate.
Okay.
It's one of the reasons why I really like the probate code, because it's very clear.
Yeah.
This is your priority of appointment. Cousin Lewista doesn't outrank grandma, and grandma doesn't
Yeah.
outrank the wife. So
Right.
it tells you, and it also tells you
Wow.
how much people are supposed to be paid.
Right. Okay.
So the petition will also include a report of administration. So all the actions that were taken. I had like 5 creditors' claims. All 5 were valid. We were able to, the claims were X amount of dollars. We were able to negotiate it down to X amount of dollars. They were either paid or they will be paid, da, da, da.
Mhm.
We had 5 houses. We sold 4 of them. Everybody agreed that the 5th one would be gifted, or it would be an
Mm.
in-kind distribution. So in lieu of actual cash, it would go to, the youngest sibling who is
Right.
disabled and needs a place to live and couldn't
Yeah.
find a place to live without, has always lived there.
Right.
So
Right.
whatever it is, you
Right.
need to talk about what action was taken during the
Right.
probate.
Okay.
You'll also need to talk about payment of estate taxes. And then at the end, you'll talk about a distribution. So at the end of all of that, after paying all of these things, including the lawyer and the personal representative, there is $500,000 left. Of that $500,000, there's 5 beneficiaries that will get payment. The administrator can get paid as an administrator and as a beneficiary.
Okay.
So everybody will get an equal share of $100,000. And those people are Jane, John, Joe, Jack, and Jill.
Right. Right.
And so then the court looks at it and says, okay, they look at the attorney's hours and their bills that they submitted. Okay, the attorney, that's fine. Personal representative, okay, that's fine. They did all of that. I agree with this. I agree with that, and all of this. And then they approve your claim. And so at that point, it's done. Well, before you even get to the hearing, so you filed it, and now you have to do the notice again. Remember how you had to notify the heirs and the beneficiaries at the beginning? We're going to court. They have to receive it before 15 days before the hearing, because if they want to go and object, well, I don't think she deserves that amount of money because she didn't do no work. Anything can happen.
Wow.
Or I don't think the lawyer earned that much money. The lawyer just sat there, and the court's like, the bills are reasonable. Their statutory fees.
Right.
They didn't do, it's not like they, did anything crazy. They're not asking for anything, but people can object. So you have to give them notice of the hearing so that they can go to the hearing and show up. Then you have your hearing. If the court grants your petition, again, they've read through it, everything looks good, then that's it. You can distribute the money.
Okay.
And you can close the estate bank account. So at this point, I usually advise all of the personal representatives, we have probably been done. Our relationship probably is done like months before this happens. Like we may have sold the property within the first 4 months, and then you have 6 months before you get to this part. I always, 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 always talk to my personal representatives and say, is this fun for you? Do you like doing this? Do you like talking to me every day? I know I'm nice. I know I'm fun, but do you like talking to me all the time? Do you like talking to your lawyer? Do you like talking about furniture and clothes and trophies that your little brother earned in Pee Wee League that you can't find, but he knows they're at the house, but they're not there, so he thinks you do them? Do you like doing this? Like, is this fun for you? This is how you want to spend the rest of your days doing this? If not, get a trust. Get a full estate plan.
Yeah.
And I have a list of lawyers that will be happy to help you write an estate plan. Because this is not fun. This is work, and it's emotional, and it's stressful, or it can be stressful. And so I always talk to them at the end of the transaction. You see how fun this is for you? That's how fun it's going to be for your kids if you do this to them. So you need a full estate plan, and we'll talk in another video about my tips for not getting into probate, which includes getting a full estate plan. And I also talk to them about taking their share and investing it. Instead, if you are lucky enough to get some money out of a probate, take it and put it into something that can build some wealth for you. And then go out and call an estate planning attorney and make sure you put that property in the trust. Because I want to stop this from happening. I'm here as the realtor and as the attorney on the video, but in life, if we work together, I'll be working as the realtor. I'm here to help you. I'm here to help you, to advocate for you, and to help you get the most money for the estate property as possible, because like you, I'm the fiduciary also. You're my client, but you're only my client in a representative capacity. So what I'm doing, what I'm selling the property for, is to enrich the estate. And the estate has beneficiaries, and then ultimately the court is looking over all of us to make sure that I'm working, and you and I are working on behalf of getting the estate the best value. So as part of my fiduciary duty, I'm telling you that while it's been great to work with you, and that I'm here to work with families like yours that end up in this situation.
Right.
My wish is that
Mm-hmm.
nobody is in
Yeah.
this situation.
Yeah.
Nobody. And
Right.
a trust is really, and a full estate plan that includes a trust is one of the best ways to assure that you don't go into probate court. It's not foolproof. There's no guarantee. People
Mm-hmm.
sue for whatever. They can sue the
Mm-hmm.
trustee and you end up in probate court. But not coming to probate court because nobody did anything. You didn't want to talk about death, or
Yeah.
you didn't want to write a will, or you wrote a will only. We'll talk about all of those types of things, but this
Mm-hmm.
is a long process. There's a lot of moving parts in here. I only
Yeah.
really talk about what I did for this amount of money, this amount of
Right.
time.
Right.
Um, I'm only in it for as long as it takes to sell the property. You're in it for before you can talk to
Yeah.
me, and
Yeah.
well after you can talk to
Right.
me.
Right.
And I don't wish this on you, honestly.
Mm-hmm.
My goal is to make it as nice and smooth as possible,
Mm-hmm.
but I don't want you to do this. And I
Yeah.
want you to figure out a way, and I'd be happy to talk to you about it, how not to end up in probate
Right.
court.
One follow-up question for you, and I know that we're wrapping this up, but coming back to reverse mortgage, and again, given what's going on with COVID, if someone has that title in a trust and it was the loan itself is in a reverse, or the property has a reverse mortgage, does that trust then eliminate, or does it at least stop that servicing company or slow them down then?
I'm not clear on the question. So the mortgage is held by an individual, but the property
Well,
is
let's say there's a reverse mortgage on the house,
okay.
but the title is in a trust.
Okay.
Does that slow down that reverse mortgage servicing company from just being able to? So in other words, does it help avoid that luck of the draw of, I just happen to really have a really nice servicing company that's willing to give me to work with me, versus those other ones that you just said, I'm sorry, too bad, so sad, we're taking the property. Like you have so much time to be able to perform, and if you don't perform within that time, we're not giving you any extensions unless the attorney goes to court. If the title is in a trust, does that make any difference when there's a reverse mortgage, or it's just?
No.
Okay.
They want their asset. At this point, they want their property.
Got it. Okay.
And it doesn't matter if the trust is going to pay for it. It doesn't matter if the individual is
Right.
going to pay for it, if the estate's going to pay for it. They want their asset or the value of their asset.
Got it. Okay.
Yeah.
Okay. I was just curious. All right. Well, did you have are you done any more I'm trying to use a lawyer term, and I'm not a lawyer.
Conclusory thoughts.
Thank you.
In
There you go.
conclusion,
Right.
no,
Right.
I think I said everything. I know there's a lot more to say,
Right.
because we're going to specifically talk about limited and full authority. Those are that's a full-on discussion.
Yeah.
So we may do that in a video and on a live if we want
Right.
to answer some questions.
Okay.
And then we'll do some tips, like I said, about how to avoid
Right.
probate. Yes, how to avoid probate. And once you're in, I've talked about once you're in probate, but tips on how to not end up here. But other than that, nope, I think this concludes our video for today. Hopefully I've spoken slowly enough, or you can
I
call me.
along. The great thing about video is that you can always pause, go back, rewrite, or they could just call. So that's the other thing. Just call and then say, hang on a second, Erica, let me write that down. Hold on a second. So anyway, well, thank you everyone so much for tuning in. I know, as usual, like I said, I learned so much from watching these videos, and I've been in this business for some time. So I'm really hopeful that those that are viewing it have learned something, have been able to get some gainful knowledge from it. And more importantly, to Erica's point, please understand that our purpose of putting this together is not solely just to get more business, but it really is so that we can try and help people to avoid these problems. particularly now more than ever, you know, depending upon when people are viewing this video. It is at the height of COVID right now. We're taping this at, you know, end of September, beginning of October. 200,000 people have now died in the United States. They're still monitoring whether or not we've had a surge in cases and deaths after Labor Day. We're heading into flu season. So we know that those circumstances are going to complicate matters even more, which is one of the reasons why I've been asking a little bit more probing questions about reverse mortgage, you know, and just other ways that are able to help prevent people from losing properties and families from losing properties, and just understanding the process. So with that being said, please feel free to reach out to either one of us with any follow-up questions. We'd love to be able to help. We're here to educate. We're here to help. And, you know, we really have everyone's best interest in mind. So thanks for joining, and we'll catch you all next time.